supplementary list for orders. Item number 1.
May I please? Here, the petition for recalling of an order in for lordship. If a lordship will permit, I have given a spiral paper book. The crux of the matter, my lord, around 7 years back, the petitioner had approached your lordships in a PIL. In that PIL, your lordship had directed the collector to make a detailed inquiry and take as per legal action as per it. If your lords, and before that also, there is a report at the instance of the commissioner endowment conducted by divisional inspector of endowment commissioner. If your lordship from that paper book will go through it, this is the crux of the point, man. Even though the order, because this temple in question, your lordship may be knowing, there's the second biggest temple in the state so far the Lord Jagannath is concerned, both in reputation as well as in earning, as well as so far the devotees are concerned. Large number of gathering, no other temple is there to gather than the temple in question. Here, there is huge after the brothers came into picture. This petition is a PIL. In the internship fighting between the brothers, the entire mismanagement has occurred in the temple.
Right.
Income, the management, the behavior, so far the disposal of the illegal disposal of the property, so many things. I have stated everything. And in that case, I approached my file representation in 2015 to the commissioner, thereafter to the collector. Right. And thereafter, I approached this honorable court in a PIL. Right. Your lordship, I received from the paper book, page 147, the inquiry report of the collector. After hearing all the necessary parties in a detailed order, he has given a report, which is yet to be implemented.
Right. So just to be clear, sir, there are two applications now before us, right?
Yes. Sir.
Your application is 414024.
Yes. My application for recalling of the order
is 4024.
Yes. Identical petitions.
And 11286 is Mr. Rao's.
Yes. Because of the paucity of time could not be.
My land friend's application is
4140.
4140.
My lord.
4141 or 4140?
4140.
Two cases in WPC 21200, that is 4141. In WPC 21202, that is 4140.
And yours is in only the first one?
In both the cases. In the other case also, my case is IA 4025.
Whose is 11286 of 21?
11286
of 21 in WP Civil 21200. Opposite party number 3.
Well, that is this 4141 was dismissed by your lordships.
Correct.
Then again, this application was filed to recall.
To hear that again. Oh, this is filed by you, is it? Or him?
Mine.
Oh, I see. So today we actually be hearing 4141 again.
Yes, ma'am.
Milord, I think Bhagyadhar Biswal is dead in the meantime. He expired on 8th February.
Oh. Then the applicant has died. He says Bhagyadhar Biswal has died.
I don't know.
I
don't have an instruction. Since I have heard it now. But however, my lord, this is a PIL.
No. The application is by Bhagyadhar Biswal.
No, this is a PIL, my lord.
No.
Yes, application.
We are hearing this application.
Lord,
the applicant dies means what do we do?
No. Your lordship is correct. But the whole point is that this is a public interest litigation.
Maybe,
through the petitioner.
No, for rehearing, then you'll have to file somebody else's application.
Yes, ma'am. Technically, your lordship is correct. But because there are large number of applicants, persons made representation to the collector.
Correct.
To avoid the cost title, I just brought the number 1. There are a large number of people, those who are.
Mr. Ashok Mohanty, when did Mr. Biswal die?
Milord, as per my instruction, Milord, he died on 8th February 2022.
So maybe that's why you are not
your lordship, either anybody can come or your lordship can fix or because PIL will not await. As your lordship knows, a decade back.
We are not saying that.
Yes.
Only since you're asking for recall of an order through this,
my lord.
Yes. You'll have to file it through a proper person.
Right.
Yes. If your lordship will say so, but your lordship knows that judgment by Justice Dalvir Bhandari way back in around a decade back. The death of a petitioner in the PIL will not affect the adjudication of the PIL itself.
No, you see.
Yes, well, yeah, what your lordship is saying is technical.
Correct. IA number 4141.
But the
of
whole point is that
2019.
the collector's order and the order of the appointment made by the commissioner appointing the sub-collector.
Right.
As a fit person is yet to take effect for last around 10 years. And that is huge mismanagement. I have the other writ petitions filed by the Bhagyadara. There are two other petitions which is before lordship. One is to hand over the case to the crime branch for investigation.
There are a lot of things, let him submit, thereafter we will submit.
That's what I'm saying.
I think may I be
1286.
permitted to say, my lord?
11286
My lord,
of
one thing.
2021. Huh?
This type of petition which your lordship disposed of and I have filed the recall, that actually two by me and two by my land friend. There are three petitions are pending. If those petitions are allowed also, it is automatically the writ petition revives.
Yeah, but let's deal with this. 11286 of 21. This is an application by Sri Bhagyadar Biswal, who is opposite party number 3 in the main writ petition civil 21200 of 2018, seeking recall of an order dated 13th August 2021, passed by this court, dismissing his earlier IA number 4141 of 2019 paragraph. When the application was called out today, Mr. Ashok Mohanty, learned senior counsel, appearing for
The petitioner in the case.
the original petitioner in writ petition civil 21200 of 2018, Sri Kumresh Chandra Nayak, informed the court that as per the information available to the petitioner, Sri Bhagyadar Biswal expired on 4th February, 8th February, sorry, 8th February
For this
2022.
month only. That's why I am not done.
8th February 2022 paragraph. In that view of the matter, while disposing of this application as having abated, the court permits any other party to urge the similar relief if so advised.
Madam.
All right. Now, which is the other application?
My application is 4024 of 90.
Ha.
4025.
Yes, sir.
There I have stated that after the collector's order, this present writ petitioner has filed a writ petition and that writ petition was disposed of without notice to me.
Ha.
That is my-
So what would you have to say in that writ petition is the question?
Then I have moved the Honorable
Supreme Court.
Honorable Supreme Court remanded the matter, said that the same may be placed before this Honorable.
Right.
And in my application, I have clearly stated at paragraph 12, it is humbly submitted that writ application filed by the petitioner was disposed of without notice to this opposite party number 6. The opposite party number 6 could have brought to the notice of this Honorable Court about the actual state of affairs had he been noticed and given an opportunity in the case. Here, as my learned friend was just narrating, when the collector was asked by this Honorable Court to dispose of the,
So you're Jagannath Das.
yes,
All right. So what are the facts that you have which would have made a difference to us?
yes, your lordship will find before the collector, I have filed an application. I have filed an application with all the details.
Yes, sir.
But this is an institution, my lord, which was in which I have filed an application initially under section 30 of the after the last known hereditary trustee died, there was an application under section 30 of the Hindu Religious Endowment Act for recognition of the heirs of the last known trustee, and that application was allowed.
Sir, if you are permitted to put your grievance before the Commissioner of Endowments,
Yes.
why does that not satisfy your requirement? Everybody is being permitted to put their grievance before the Commissioner of Endowments. So you are also given that same permission, sir.
No, I have I was permitted,
Ah.
and I have made my grievance. I have given my detailed grievances before the collector. That collector's order was challenged by the present. Writ
No, Commissioner. See, the order, our order which you're seeking recall of, which is an order dated 20th December, correct? 2018.
Yes, yes.
In that order, we have said, let the parties appear before the Commissioner of Endowments and put forth their grievance.
Yes.
In such event, the Commissioner of Endowments, after giving opportunity of hearing to the parties, shall take appropriate step.
Yes.
So the parties would include you also, sir.
That's right.
Huh.
But what has happened?
Lord, may I be permitted to say something, Milord? Milord, he filed the OA. Jagannath Das filed OA number 1 of 2010 before the commissioner under section 28 of the Endowment Act. Milord.
Correct.
And that OA got disposed subsequently. That order has not been challenged. 23/3/2021 order has not been challenged by him.
Okay.
So if his original application, what he seeks to recall is the cause of action giving rise from the original application.
So you're saying that this order has worked itself out. Pursuant to this order, the Commissioner has passed a fresh order.
Yes, madam.
Okay. Okay.
No, my land senior is not correct, my lord. My submission will be.
Application of 2010 was he referring on earlier your application was pending, but Mr. Manti says that that application has been disposed of and you have not challenged that order.
No, I have challenged it.
Which is that application? Which is
I
that
have challenged
application
it
in which
before
you have
the
challenged that order?
learned commissioner himself, asking for recall of that.
It's pending.
It is pending and they have appealed.
So you work it out there, sir. Why?
No, that is right, my lord. What has happened? The proceedings are two-phase. At one stage, the recognition of LRs and other things was there, and thereafter, as a fit person, this one of my brothers, the elder brother, has misappropriated the properties and did whatever he did.
Oh, shit.
Then I filed an application under section 28 of the Endowments Act to remove him from the trusteeship. That is nothing to do with the management. During pendency of that application, by exercise of power under section 28 subclause 3 of the Endowments Act, the learned commissioner has appointed sub-collector as a fit person. While disposing of the OA, maybe for my non-appearance or for no opportunity, whatever it is, the learned commissioner has reserved that portion of the order. He said, I am dismissing this application under section 28, but the order in which I have passed asking the trustee to hand over possession to the sub-collector shall be dealt with separately by me. That means that portion of the order appointing sub-collector as a fit person after removing the trustee remained intact. After that order, then he took up the matter in the management side. In the management side, while saying in this 28 application that will be dealt separately in the application before the managing side, in the management side, he again contradicted himself by saying that since 28 application has been disposed of, this has become infructuous. That I have challenged. That order has been challenged here. There are 3 orders before the learned commissioner.
You have challenged here by filing a writ petition.
Yes.
Which is your writ petition number?
Next writ petition, my lord.
591 of 2021.
Sorry? 16591.
16591 of 2021.
So all this we can hear you in that.
Yes, yes.
So why have a separate application now here?
No, what I'm saying is, after taking note of all the developments by the commissioner, the collector passed the order. That's a composite order saying that the very same sub-collector should be in charge.
So which you have challenged, say in 16591, you have challenged that.
No, I so far as the collector's order is concerned, that has been challenged by the other side.
Oh,
In
see,
these
that's
two
the
writ
original
In this
application.
16591, what have you challenged?
In 16591, I have said that since the commissioner has said in the writ petition, in the 28 application, that the matters relating to the handing over possession of the premises to the sub-collector as fit person will be dealt with separately.
So all that, so anyway, sir, and whatever you have to say, you can say it in 16591. Because there you're opposed to the sub-collector being declared a fit person.
No,
That
no,
is the
no.
crux of your problem in 16591.
No, no, I am not
That is-
opposing.
Mr.
I am
Rao,
supporting.
That is just an interim arrangement because it may take time to dispose of all the applications before the endowment commissioner. That is why the collector passed the order that till the matter is resolved there before he has just because somebody has to
Run the temple.
run the temple.
Yes, that
And
is
it's so that is how the arrangement has been made. It is because your grievance is against your brother, elder brother. Your allegation is that he is misappropriating the money. So suppose nobody will be now there and we cannot place that person because against whom allegation is there and so Mr. Mishra is wanting this crime branch inquiry or something like that in his petition. Whatever it may be, this is
another
just a stopgap arrangement. We can say that that has been made by the collector till that matter has been amicably resolved by the endowment commissioner to look after the properties and all these day-to-day administration. That is just an interim arrangement. So if you cooperate there before the endowment commissioner, it can be sorted out there quickly instead of filing number of applications here by different.
No, no.
May I be permitted for a moment, my lord? I am the mother of both the brothers of the client of Mr. Mohanty, my non-senior friend, and also Mr. Rao. I am the mother. This is an institution which was settled long back by the Supreme Court. It is a peculiar institution of Jagannath Temple where the public have also a role so far the worship is concerned. So far the property is concerned, that is a huge property that your worship will look to that report of the collector, how it is misappropriated. I have no way concerned that which brother now they are quarreling with each other. But the very purpose of the temple and the object of the temple, as your lordship will find from the judgment of the Supreme Court in this particular institution, that this is a peculiar institution where the right of worship of the public have a also role. Though it is a private endowment, so far as the property is concerned, but so far the worship is concerned, that is to the public. So your lordship may take up this matter if Mr. Mishra's can file an application for restoration of substitution.
No, but why get back to this writ petition? This writ petition, the order passed by this court has worked itself out. There have been subsequent orders. Where's the question of now recalling a 2018 order?
The whole thing now relates back to the management of the DT's properties.
No, all that can be gone into the subsequent writ petitions. Why recall an order of December 2018?
That is for your lordship to decide, because my entire purpose is your lordship may take up this matter for the greater interest of the DT and the.
No, there are enough writ petitions, sir.
Yes,
there is a whole set of writ petitions here. We are now on the applications in the first writ petition.
No, because of the
Mr. Raut's client was also a party to the OA, which was dismissed. He was opposite party number 11.
By the Mr. Mishra's client that we have dismissed, unless he of course he says fine. So that order has reached finality.
Worked itself out.
That is to be challenged. Again, it has to go to the Honorable Supreme Court. On a particular point, the permission was granted.
Correct.
That no opportunity was given. Now we find that opportunity has been given. We dismiss that interim application.
Correct.
So that order now stands. That has attended finality.
Yeah.
The moot question before your lordship is, collector has passed some order. And can that order be set aside without notice to the parties? First. Second, as your lordships have questioned me, saying that even if that order is recalled, since the order has been worked out, there is no need of again going into those matters.
Correct.
My submission.
No, and the issue is still alive. As a result of the subsequent order again being challenged before us in separate writ petition, you have kept the issue alive.
Issue is not alive.
Not alive.
Issue is not alive for the simple reason that so far as the order in 2017 passed in OA is relating to appointing a fit person. It is sub-collector. Incidentally, what the collector says and what the commissioner says, it is the sub-collector who is to be in charge. So that order now has become a question by saying that that's an interim order. The question is whether 28(3) of the Act is an independent order or is an interim order, or even assuming that it's an interim order, just like appointment of receivers and other things, when it is reserved, can it be recalled again? The net result is
a de facto trustee who has been removed from the post of the fit person is in possession of the property
Yes.
without any arrangement. A public institution without any arrangement goes to the air and under an illegal possession of a person and income is being appropriated.
No, the direction was issued to you to immediately hand it over.
Not
hand
to
over
me,
the
to
property,
the
was
client
not
of
hand
Mr.
over-
Mahanti.
No,
No, Mr. Mishra's client.
no, not my client. Client of Mr. Mahanti.
Huh.
Milord, I'm virtually sandwiched between the fight
It was
between the two
directed to
brothers.
be
I
handed
want the
over
interest
to
of the.
Sub-collector. That has not
Provided-
been done. Then again, in the police presence, that
Yes,
order was
yes,
passed.
that
So-
order has to be sustained. That's my humble submission. Whatever it is. The sub-collector's appointment by the collector has been set aside.
All that.
That order has been challenged, my lord,
Yes, that's a
commissioner.
subject matter of the separate writ petition, Mr. Rao.
In
No,
one
that
six-
is not,
IA.
that is not challenged.
16591, my lord, they have challenged that order.
Yes.
My lord, that is not under challenge, my lord, in that.
And that has
jurisdiction.
not been admitted as yet, and we have
My
not.
lord,
been-
let there be no
we have not
confusion over
filed
the matter.
counter. No,
No,
what
that
is
is
this, my
that is
lord,
factual twisting,
submission?
factual
I don't
twisting of the
understand.
matter. I'm not, no, if at all my client is now that I have given to death, assuming that he is alive. But here the petition is no way concerned with either of the brothers in fighting between them
Would I
or the
like
mother.
assume-
The whole point is that I approached before your lordship and your lordship passed an order. And whether that order can be challenged
Somebody-
by a person not in the PIL, but under the Endowment Act, without giving a proper opportunity of hearing to me. My interest is seriously jeopardized.
Yes, yes.
But so far as I am concerned, I am no way concerned with their disputes. I am the mother. Because the property, if your lordship will, I was told, if the property will put to auction between the parties, this will give at least more than crores of rupees. More than crores of rupees. And a person who is in unauthorized occupation of this entire land and the property and getting the income, if that the collector has found in this order. And the sub-collector was appointed as administrator. He was, in fact, as your lordship rightly said, that he was in continuing. Now, whatever arrangement your lordship will do, let it be done so far as the matter is finalized by them. But the entire property is mismanaged, misappropriated.
All right, IA number.
Lord, if your lordship will give me 3 minutes time, they factually here. I am no
May
way
I
concerned with the
suggest,
brothers.
my lord, this writ application may be segregated by one and taken up, my lord, authorized. It will never end, my lord.
No, anyway, we
Well,
don't have to
lordship-
sit in this combination because we are sitting in this combination only because the December 2018 order.
Sorry,
was
my
recalled.
lord.
Otherwise, the roster bench will deal with it.
Lord,
Okay,
one
yes.
thing, my lord, your lordship, just 2-3 minutes and I will only place the, if your lordship will permit, report of the collector. Here the entire things, these brothers are
How does it matter?
filing petitions behind the back. My lord, suppose if
Mr. Mishra, we have
order,
already. Mr. Mishra,
Why don't you file that interim application?
no, I understand.
you
my lord.
file it, sir. You file it and then
I
we
will
hear
file
you.
it, but just to clarify the facts, because they are not telling the facts, what is the crux of the point. The crux of the point is that before these people came to the courts, either commissioner or before anyone, I approached your lordship. The deceased petitioner approached your lordship. And your lordship has passed the order.
So you'll have to take instructions. Who will now appear? On whose behalf you now want to appear? You better take a call on that.
Many people had come. I only confined it to one person.
So you file an application, we'll then hear you.
Just for factual expert for your lordship proper decision, because whatever arrangement will make, your lordship will make. But the whole point is
they're not making any arrangement.
That is what it is necessary, because
so we will place these writ petitions before the roster bench. We are now only because this combination we are sitting only because Justice Sahu was a member of the bench which passed that order.
I am affected only with this bench alone can rectify the.
How can you say that?
The whole point.
How can you say that?
My lord?
How can you say that?
No. My lord,
we are sitting in this combination only because these applications. Mr. Mishra, you're not letting me complete a sentence. This is extraordinary. This is extraordinary. You're not letting me complete a sentence.
I'm sorry.
Mr. Rao, what do you want to say?
Madam, my humble submission before our lordships here. There are two orders. One order by the commissioner as an interim measure or whatever it is in a 28 application. There is another order by the collector. If the collector order remains, then it may be, as your lordships have rightly said, that 28 order may not be necessary, because ultimately the management will be dealt with by the collector's order. Now the question is, the collector's order has been set aside by this honorable court. And so far as that order is concerned, the commissioner says that it has become infectious. So the petitioner has become remediless.
No, you go back to the collector or commissioner. Everybody has been permitted. Just read that order properly, sir.
As
everybody has been permitted to go before the commissioner.
As it was pointed out,
all the parties are permitted to go before the commissioner. That's what the order said.
That is correct, my lord. But that proceeding is no more there.
Yeah. So whatever you have to do pursuant to the order passed by us, an order has been passed with the commissioner. If you're aggrieved, you will challenge it. If you've not challenged it so far. If according to you, you've not challenged the commissioner's order, by all means do that. Nobody prevents you, sir, from doing that.
Commissioner's order is totally different from the order of the collector.
So you challenge the commissioner, you challenge the collector, you can always file a writ petition. You have filed a separate writ petition. What have you challenged? Collector's order or commissioner's order in that? What have you challenged in that separate writ petition?
I am challenging only commissioner's order.
So if you want to challenge collector's order, do that.
Collector's order is in my favor.
All right.
Therefore, that has been challenged by the other side. That was set aside without hearing us. That is the grievance. Without hearing us. Therefore, if the collector order stands, no other litigation is necessary. All the cases can be wound up.
That is the only thing I was going to submit. Even though your lordship with permission is dead, without substituting.
Yes, Mr. Ashok Mohanty.
My lord.
You tell us. He says the collector's order has been set aside by us without hearing him.
Only submission is that collector order was set aside sometime past, my lord. Your lordship will kindly appreciate. Then this honorable court directed all the parties to appear before the commissioner under section 28 proceeding. Section 28 proceeding got dismissed, my lord. And that has not been challenged. As they say, they have filed a recall petition before the commissioner, which is pending. Then subsequently, the commissioner has also passed an order that in view of the dismissal of the OA, all interim orders passed earlier stands vacated. Now they have challenged it in 16591 of 2022. But that is yet to be admitted.
No, what happens to the collector's order?
No, collector order has been vacated, my lord. It merged with the order of the commissioner, my lord.
No.
So the collector's order has merged with the order of the commissioner?
Yes, my lord. Now,
and the commissioner's order is under challenge.
Now they are wanting to put the clock back to the position before passing of the original passing of the order in the writ application.
You'll have to tell that this awaits.
My lord, once the water flows, my lord, I can't understand how it can fly upward, my lord, flow upward, my lord.
Now the problem is the collector order was shown before the commissioner to get it dismissed. Now they say.
And that is 16591, you challenge. If the Honorable Court admits it and issues notice, we'll give a response.
All right.
Madam, may I clarify one small thing, madam?
Yes.
The commissioner's order is in an application under section 28. 28, as your lordship knows, to removal of a trustee. That is nothing. So for collector's order is concerned, that is under a PAL pursuant to your lordship's direction. After taking note of everything, he passes a reasoned order. This is not an interim order.
What powers is he exercising, collector?
By virtue of your lordship's order?
No. Under the act, is he exercising any power, the collector?
Yes,
No.
No,
Then let's not get into that, sir. Let's not get into
Collector
that.
has the power to supervise the institutions.
No, under what provision?
I think it is section 73.
No.
I just
Anyway.
just 1 second, my lord, I will tell you.
In the written account.
There is a provision, ma'am.
Commissioner thila bole collector change kare.
So this is what we're doing. 4024, Mr. Rao, we permit you to raise all your contentions in other petition that you have raised, filed already.
My lord,
Yes.
my lord, that-
IU
my lord,
4024 of
your lordship
2009.
may pass any order, I am not saying, but let me say that the scope of the present collector's order and the scope of the commissioner's order are different, and this cannot be placed there. That is why my problem.
All right. IA 4024 of 2019, pursuant to the order passed by the Supreme Court of India on 11th February 2019, this IA has been filed by opposite party number 6 in the main writ petition civil 21200 of 2018, seeking recall of the order dated 20th December 2018. Paragraph. The reason for seeking recall is that opposite party number 6 was not noticed by this court when the when the said order was passed. Paragraph. It must be noted here that when the order dated 20th December 2018 was passed by this court, it was on the basis that one Shri Manoj Kumar Mishra, senior advocate, had been instructed to appear on behalf of opposite parties 5 to 8. And this was recorded in the order dated 19th December 2018. After the order dated 20th December 2018 was passed, IA number 248 of 2019 was filed by only opposite party number 3 to say that Mr. Manoj Kumar Mishra had instruction to appear only on his behalf. Full stop. Taking the above submission on record, the order dated 19/12/2018 was corrected to indicate that Mr. Manoj Mishra appeared only for opposite party number 3. Paragraph. Be that as it may, the order dated 20th December 2018 has now worked itself out. As pursuant to that order, the commissioner has again passed a fresh order. This fresh order of the commissioner dated, Mr. Ashok Mohanty, what is the date of the commissioner's order?
That is dated is 1 minute. That is 23/3/2021.
23/3/2021 has been challenged by this very applicant in writ petition civil.
No, my lord, he has filed a recall petition against this order before the commissioner.
Has been challenged by by this very applicant by filing a recall application before the commissioner. Incidentally, this petitioner has also filed a separate writ petition civil 16591 of 2021,
Challenging order dated 15/4/2021,
challenging an order dated 15th April 2021,
passed by Commissioner of Endowment.
passed with the Commissioner of Endowments. Full stop. As the court understands it, after hearing the submissions of Mr. Rao, learned counsel for the applicant, all the issues that he is seeking to raise are to be agitated in all the other proceedings. One in a recall application pending for the commissioner, and in the writ petition mentioned herein before, which is pending in this court. The court therefore sees no reason in the above circumstances to entertain the present application and declines to recall the earlier order, since adequate opportunity is now available to opposite party number 6 to vent his grievances in other proceedings. The application is accordingly dismissed. All the other writ petitions, you say placed before the roster bench on 5th April 2022. Right.
You have also fixed it 50.
list, fresh admission, item number 1.
My lord, it is the covered matter, my lord. But that one is the sub versus that you know.
Yes, Lord. Lordship may dispose of all the writ petition except one item that,
No, disposed of what?
That previous order you have given.
yes,
In view of the order dated 18/11/2021, in writ petition civil 35584 of 2021, these petitions are disposed of in the same terms. Which is the one which is not to be disposed of? You said except one. Which is that one?
Lord, that one WPC number 15324.
What is that?
In that case, my lord, NOC has been issued to out of state, that is Chennai. But cause of action arose there.
All right. Who is appearing for the petitioner there? Just call out 15324.
15324 of 2020.
None appears for the petitioner dismissed non-prosecution. All right.
Supplementary list, item number 2.
This my lord, unfortunately, the new council came in and he missed, my lord, the matter.
You tell us what the main matter is about.
Yes, main matter, my lord, arises out of a writ petition 17B disposed of by a bench consisting of the Honorable Chief Justice and Honorable Justice BP Rautray. So therefore, it has to go there. That's the reason why.
All right. The order is recalled. No. This is for recall of an order passed by that bench, is it?
Yes, yes.
Then this,
No, review.
that's right.
The main petition is review. And
Review
this-
got dismissed for non-prosecution.
No. My lord, the non-prosecution of the review.
That's right, I'm saying.
Yes.
Review got dismissed for non-prosecution.
Yes.
All right. Then we can't recall.
But review is pending. No. My learned friend is, the review came up, my lord, and the review, there was non-appearance.
That's what.
Yes.
So even this application has to go only before that bench. sir?
Yes.
It is arising out of WPC number 8128 of 2019. Same appeal. Not from.
My lord, I beg your pardon, my lord. I think I stand corrected, my lord. On instruction, my lord, I stand corrected, my lord. I think I made a mistake. I made a mistake, my lord. My lord, it seems the main writ petition has been dismissed.
No. Just see the order dated 7/9/21. You are seeking a recall of that in this application, right?
Yes, my lord.
Today's application number you give us, sir.
Yes.
No. What is today's application? 3724 of 2021. Correct? 374 of
Yes.
2021.
Yes.
The prayer clause in this application, please read it.
May gracious writ application number so and so in it to its original file by recalling the order dated 13/12/2021.
So that is this combination only.
Yeah. This combination. Yes.
So the main writ petition, tell us about the main writ petition then. That is now getting restored. You can still tell us about the main writ petition. It doesn't have to go anywhere else.
The writ petition. No,
Challenges an award dated 26/9/2018.
Yes.
So you tell us about that.
Unfortunately, one of the brief might not give me a passover of the app because the brief came late last night because it's getting listed the second day.
All right. You say for the reason stated therein, the order dated 13/12/2021 is recalled and writ petition civil 8128 of 2019 is restored to file. List before the roster bench on 4th May.
My lord, my profuse apologies, my lord, because I understood otherwise.
Outside, not a problem. Right.
Supplementary list, item number 3.
Because I'm verily conscious that the lordship wants to hear the matter.
That's right.
Item 3.
Similar matters your lordship has already fixed.
Yeah, please, my lordship. My lordship, this petition deals with the anomaly of the Arbitration and Conciliation Act, the Commercial Courts Act, and the appointment of the presiding officer of the Commercial Courts Act.
So we already have a bunch of petitions.
Your Lordship, the petitioner here challenges a notification dated 13th November 2021, which confers the power.
No, so there are already matters on the same issue, madam.
Yes, my lord. There's an identical matter where your lordship has
Correct,
passed an
correct.
order.
When are those matters coming up?
Ma'am, 28th February 2020.
All right, Monday. So we'll simply list on Monday.
Highly obliged.
Right.
List on 28.
Supplementary item number 4.
OA transfer matters.
All right. Doesn't survive.
Your lordship, can the council please pray for an interim order?
Between now and Monday, there are exactly 2 days left, madam.
Highly obliged.
Again. Order item 4, my lord. 10843, the 4 matters are already transferred to this and all.
All infructuous, sir. Yes, it's all infructuous. Yes.
Supplementary item number 5.
May I please, your lordship. Here, my lord, the present petitioner my lord, challenges the illegal construction of a open road, my lord, open pendal over the village road, my lord, recorded under Khata number 130, plot number 78 of Moja Brotan Kala in the district of Sundargarh, my lord, for which, my lord, there is blocking of village road and causing hindrance in playing vehicle, my
So
lord.
what is there to show your representation has been delivered, not made, delivered to the collector? What is there to show your representation got delivered to the collector?
Page 5, my lord, annexure 5, my lord, page 15.
What is there to show? Have you understood the question?
Man,
What is the question?
that is the pending, my lord.
What is the question, sir? What question did I ask you? Sir,
Sorry,
you ask
Miller.
him. Just you ask.
Do you have any acknowledgement?
No, my lord, no.
Receipt of the representation?
No, that they have given in hand, my lord.
Is there any receipt acknowledgement?
No, no, my lord, I have no acknowledgement.
Say that.
Since there is no proof of receipt of the representation by the authorities, the court is unable to pass any directions in that regard, permitting the petitioners to make a fresh representation. This application is, this writ petition is disposed of.
Supplementary item number 6.
May I please, madam. Item number 6 and 7. I have filed before this case for withdrawal of the OA number, my lord. At the time there is no court, tribunal.
It's all infructuous, sir.
Yes, yes, infructuous.
Both 6 and 7.
Yes.
All right, all infructuous. All right.
6 and 7, well.
7 is a PIL.
There are 2 items in item 6.
6, there are 2 items, sir, not 7.
Yes, yes, six,
All
six,
right.
two items.
7, call out 7 now.
Item number 7, sir. Supplementary list item 7.
You see a PL, my lord, the defects are very minor. They can be ignored because I have handed over the representation to the.
So this train not stopping and all is not, somehow I will not entertain this kind of petition. You say the prayer in the present petition is for a direction to the railways to make a train stop at Naraj Maratpur railway station. The court is not inclined to entertain these kind of petitions as PILs. The petition is dismissed.
Item number 8.
Voted, my lord.
All right.
Really, 8 my lord, infructuous, I am permitted
States that
to.
the petition has become infructuous. It is post of.
Item number 9.
The similar matter, lordship has fixed yesterday to 29th June.
But in this case,
There are many defects, sir. We'll keep it for 29 June.
Yes, madam.
that is another case.
Mr. Vidyadhar Misra, senior advocate.
So that if you're insisting on this, you remove all the defects, sir, first. There are several defects pointed out. Kindly remove the defects.
I'm sorry to say, I have been reminded of your lordship's utterances in the felicitation function that any controversial thing that arises, let it come next week or day after.
I'm sorry, when your petition is defective,
while
when your petition is defective, you have to remove the defects first, sir.
While defects,
There is something that you have to do, you please do it, and then we will entertain it.
defects are not so fatal. Right?
No, they are.
No,
You have to remove your defects, sir.
Lord, I have challenged the ordinance.
I know, but you have to remove the defects.
Lord, I have challenged the ordinance.
Right.
Ordinance that is Annexure 1 at page 17.
We have seen that, sir. Yesterday, there is another petition challenging the ordinance. We have entertained it. Yes.
Let me
You have to familiarize yourself with the order that we have passed yesterday, sir.
No, let me be allowed to Let me be allowed to present my case.
So if you remove the defects, certainly.
I will remove it.
So when will you remove it, sir? When will you remove it? Tell us. We'll fix a date when you will remove it.
Within 2 days.
Within Mr. Kare says that the defects pointed out by the registry will be removed by him within 2 days. List immediately after removal of defects. All right.
Well, I have a prayer, but I have challenged the ordinance, and I have also prayed.
So the more quickly you remove the defects, the better.
Lord, let me be allowed to argue my case. Lord, the ordinance, your Annexure 1 at page 17, your Lordship will see.
Mr. Kare, have you listened to the order that we have dictated?
Yes, I have.
Please, therefore, first remove the defects. We'll hear you after the defects are removed.
But then I'll pray. I'll remove the defect to.
So the order we have passed for your benefit, I will repeat the order. For your benefit, I'm going to repeat the order.
Yes, that is.
Mr. Kare states, this is the order, sir. Mr. Kare states that he will remove the defects pointed out by the registry within 2 days.
In course of the day.
Full stop.
Let it come tomorrow.
No. List immediately after removal of defects. Full stop. Yes.
For admission item number 10.
No, when it will come. When it will come.
What is this? How much time to repeat?
When it will be listed.
Order is very clear. It will be listed immediately after removal of the defect.
I have prayed for urgent stay of the matter. That is the problem.
We are following the same procedure for everybody. There cannot be departure. Please try to understand with all your experience. Why are you insisting?
This is not unnecessary.
Is saying that if the defect, the matter will be.
The honorable court cannot be a silent spectator of the illegality.
Remove it in course of the day. It will be listed on Monday. Within 2 days, the heaven is not going to fall down. We are following a procedure for everybody.
When it will be listed? When it will be listed? I will remove the defect in course of the day.
Order is very clear. There is no ambiguity in the order. Immediately after removal of the defect, the matter will be listed. That's what my lord said. Immediately after removal of the defect. You remove it today, Monday the matter will be listed. Please try to understand.
By Monday, there is likelihood of notification, final notification for election. In such event, my writ petition will be.
When it was filed? When this matter was filed?
Item number 10.
List before a bench of which Justice Mahapatra is not a member. On 7th March.
Item number 11.
May I please also I'm appearing on behalf of Mr. Rautray. Due to infection in his eyes, he is unable to read and see. Kindly be taken up next week.
What is the matter, please? Tell us what the matter is about.
So here, the petitioner has challenged a notification.
No. Which is your writ petition number, madam?
It's 21530 of 2013.
No, actually.
Item 11.
11. Okay. Caste certificate. You have applied for a caste certificate.
Yes, my lord.
They filed a detailed counter. creamy layer. I think he falls on the wrong side of the creamy layer. You've not filed any rejoinder, madam.
I may be
This
permitted
counter was
some-
filed way back. The counter was filed in 2015 itself, 4th August 2015. And they say there is a creamy layer corrigendum issued.
I may be permitted 1 week time so that I could comply with the order.
There's no compliance of anything. There's nothing to comply with.
I'll file the rejoinder.
No, not now. Madam, it's 2022. You're only challenging an office memorandum. So that, I don't know.
77,040.
You may have to file a fresh petition. You say the challenge of the present petition is to two office memorandums. Is to an office memorandum dated 29 January 1994 and a consequential OM dated of the same date issued by the Government of Orissa Tribal Welfare Department. In the reply filed to the counter affidavit, it is pointed out that the corrigendum has been issued to the said OM by a letter dated 17 July 2014 that provides for determination of the creamy layer. Full stop. Copy of the said corrigendum has been enclosed with the counter affidavit. Full stop. Despite this counter affidavit being filed way back in 2015, till date, no rejoinder affidavit has been filed. Without a challenge to the corrigendum, it is not possible for the court to appreciate a challenge by the petitioner only to the main office memorandum. Full stop. If so advised, it will be open to the petitioner to file a fresh petition in that regard. The petition is disposed of.
Item number 12.
In this case, a challenge made for the construction of a private power plant in the district of Benkan, my lord, by abandoning the entire land acquisition process, my lord. And for this, my lord, notice has gone to the opposite party. Only counter by IDCO is filed, but the second copy is not in the as it reveals in the cause list. And my lord, so far as the opposite party number 8, to whom the 4-1 notification was made, the notice was returned unserved as because it is left out. So my lord, the entire process has been vitiated. The land acquisition process for this Landco private power plant. My lord. That
When
is
did the
OP
acquisition, when was
number.
the acquisition started, sir?
That is in 2006, the MOU was signed in 2006. And the forward notification made in 2008, my lord, that is for OP number 8, Lanco Group Limited. But subsequently, by Annexure 5, the 6-1 notification was made for OP number 9, that is Lanco Bhavanda Power Plant Limited, my lord.
What is the date of Annexure 6, sir?
Annexure 6 is that is 26/9/2006. That is the MOU in between the government
No,
and
what is the Section 6 notification date?
Section 6 notification date, my lord, that is that is 14/8/2009.
So when have you filed this writ petition, sir?
That is in first round was filed in 2015, my lord. My lords may come to para that I have quoted the previous order, my lord, of the Honorable Court. That is at page 13 of my writ petition, my lord. That is writ petition number 13659 of 15. And my lords had ordered to file a representation for proper
How can there
inquiry.
be representation for these kind of things, sir? I don't understand. You people also keep on asking for that relief. How can there be representations? What happens after a Section 6? You educate us, sir. What happens after a Section 6 under the Land Acquisition Act?
That the direct purchase of by abandoning the 4161 notification, direct purchase was made for the supposed patent number 9, my lord.
When?
That is in 2011.
Then how can you challenge the 4 and 6 then? That is infructuous. The challenge to Section 4, Section 6 becomes infructuous if they have gone for private purchase.
Yes, my lord.
Then your prayer does not survive.
But my lord, kindly turn to the that land acquisition. I have not challenged that land acquisition, but the direct purchase over the.
No, come to your prayer clause, sir.
Yes, my lord. That is as to why construction for Lanco Group Limited and Obligor, Lanco Bhavanda Power.
How can you question their abandoning the Land Acquisition Act proceedings? I don't understand. How can you question that?
My lord, kindly turn to Annexure 7 series.
All right.
That is on 20 May 2011.
And you are filing this in 2016, sir.
That is in 15.
You can't. You are just coming at your own sweet will.
In 2015, my lord, the first TIL was filed. That was disposed of for filing a representation, and the representations are under Annexure 12 series, my lord.
So these are not matters for representation. This is the whole problem.
Yes, my lord.
If there's a private sale, how can a representation solve that issue?
Pursuant to my lord's direction.
Somebody has sold, somebody has purchased, correct?
Yes, my lord.
How can you prevent a person who sold from selling? Have you made the sellers a party here?
While the 4161 notification.
Sir, have you made the sellers? Mr. X owns land, okay?
Yes, my lord.
But the private sale, he has sold it to Mr. Y. Y is a company, X is an individual. How can you in PIL try to stop that?
But there is gazette notification, my lord. 461 notification are there.
They have abandoned that, sir. They've gone for private purchase.
Yes, my lord.
How can, where do you get locus to challenge it? Question number 1.
There is section 48 of.
So you're not waiting for questions to be asked. It's okay. I'll ask Justice Baba.
Yes, my lord.
What my lord is saying. Land acquisition abandoned, private purchase. Yes.
Under section 48, my lord, the proposal has
try
to have.
Try to understand the question.
Yes, my lord.
The government has abandoned that land acquisition proceeding.
Yes,
now
ma'am.
they are acquiring privately. The buyer and the seller, they are not parties to this writ petition. Have you made them parties?
There are 500 acres, my lord.
As it appears from the prayer, your main grievance is adverse impact on environment ecology.
Yes, my lord. That is
You
there.
approach NGT, there is a forum, there is a pollution control board, there is a NGT.
So,
why
my
the
lord,
writ petition? If
let
your
Annexure
grievance
12 series be
with regard to
disposed of.
environment and ecology of the area, you can always approach the NGT.
Yes, my lord. Let my Annexure 12 series be disposed of if it cause of action suffice. Thereafter, they will.
It is open for you under the law. No representation is necessary.
We say from the prayer clause, it appears that the petitioners aggrieved by the abandonment of the initial process that was commenced for acquisition of the lands in question under section 4 read with section 6 of the Land Acquisition Act 1894. Admittedly, the company in question, for whose project the land was originally proposed to be acquired, went in for private purchase. Full stop. Neither the individuals who sold their lands nor the company which purchased it through private purchase are being made parties to this petition. Consequently, it is not possible to entertain the prayers for a mandamus to the government to somehow resume the land acquisition process under the LA Act 1894. In any event, that act has now been replaced by a 2013 Act. Full stop. Paragraph. The other grievance of the petitioners regarding threat to the environment and ecology as a result of the project can be agitated in other appropriate proceedings in other fora. The petition is accordingly disposed of.
I am appearing for OP number 7, 8co.
One submission, my lord. That is the Rengal right canal. That may be observed, my lord. That to be protected. That has been caused damage by this opposite party number 8 and 9. Rengali right canal that was established in year 1990 for irrigation facilities, my lord.
No, you can approach.
Yes, my lord. That may be observed. So, my lord, I can
not required.
Rengali right canal.
Make a prayer.
That is in the embankment of Rengali right canal. This company is existing.
All right.
I am appearing for OP4, my lord.
My lord, may record my appearance for OP number 7.
All right.
8co.
All right.
I am for state pollution control.
All right.
Item 13. Item number 13.
None appears. What actually? This is some registrar. Sorry.
He said registered so motto.
We are just seeing what this is.
SCV medical firing.
Fire.
There was a direction given regarding that complaint.
My lord, can you see the order dated 2/6/2016?
Yes, 16. That.
This affidavit of compliance has been filed.
Yes, that was filed, but that was long ago. It was filed 2016.
No, filed on 22nd July.
Yes, 22nd July 2016.
So
in the meantime, more than 5 years have elapsed, so I have to obtain the present status.
Yes, file a fresh appeal indicating the present status.
They filed an affidavit here. Very detailed affidavit. Will be implemented in other buildings. All right. A fresh affidavit be filed by the superintendent of SCB Medical College on the compliance with the detailed directions issued by this court on 2nd June 2016. The affidavit be filed at least 1 week prior to the next date. List on 9th May.
Item number 14.
My lordship, in this matter, my lordship, the state was to file the counter, my lordship. It has not yet been filed, I believe.
But I find the counter affidavit is ready, but it is not signed. I'll take a small adjournment.
Mr. D.K. Manthi states that the counter affidavit will be positively be filed by 7th March 2022. Rejoinder if any be filed for the next date. List on 16th May.
Hearing item number 15.
Obliged, my lordship.
15 stands covered. One first matter is covered, but covered by your lordship's own order. Also, kindly the third paragraph में let's see back.
Starts at paragraph 9 of the.
Room to more appeal right है. आपन क्या क्वेश्चन के room?
Yes, sir.
Milord, here the question number A and B has already been admitted, but in similar matter, Lordship has disposed of one matter which I've supplied. But Lord, paragraph 3 is not sought to be argued before us by Land Council but department that the above constitutions are erroneously made. That
Yes, you never argued that the concession was erroneously made.
but here that order that was mentioned, but here in the tribunal order, he was argued and to page 23 of that Milord, your Lordship may not dispose it because in page 20, the time of hearing, they are submitted a respective request of different valuation closing style where CIT will error in allowing the favor of the assessee, relying the condition coordination based tribunal decision earlier year and prayed for allowing the appeal. Contrary, relied the order of the CIT appeal. In this case, they are also your Lordship that is there.
We'll simply say in view of this order.
Yes,
There's no need to get into details. You say in view of the order passed with this court on 21st February 2022 in ITA number 5 of 2014, the questions, we've already framed the questions?
Yes, it was admitted earlier.
A
and B.
Questions A and B framed by this court by its order dated 3rd March 2020 are answered in favor of the SSC and against the department. The appeal is accordingly dismissed. Right.
The next three items. Let's kindly take up ITA 20 first. Here is a substantial question you have framed. Find place.
The order which I dictated is an ITA 14 of 2018.
And this is supported by the judgment of Delhi High Court. I'm just supplying lots of kindly place the running page 10. Question number 1. Italic 1. Whether on the fact and certain the case, the tribunal is correct in quashing the assessment on the ground that reassessment dated 31/5/2015 has been completed without issuing notice under 143 of the Income Tax Act 1960.
143(2).
Sorry, 143(2).
143(2).
Yes, 143 of the Income Tax.
That your Lordship
I have not admitted. Let me wait, sir. But here, if your Lordship see the judgment of the tribunal.
Yes.
Basing on this one of two judgment of the Kerala High Court that has been disposed of, but here one of the judgment of Delhi High Court, you also kindly see this similar question is allowed in favor of the department. That is the Commission Income Tax versus Madhya Pradesh Energy Corporation Limited. And paragraph 11, sales and tax. It is noted that the impending assessment in response to notice under Section 148 of the Act, and the Act does not specifically provide that the assessment under Section 147 of the Act will be after issuance of notice under Section 143(2) of this Act. In fact, the assessing officer has a basis of jurisdiction to assess the income terms of 147 and Section 148 of the Act, whereas reason to believe that the income has escaped assessment. On presumption, on submission of the non-issuer notice under Section 142 of the Act, we are of view 143(2) of the Act. We are in view that the finding of the tribunal in this regard are not as per the scheme of the provision Section 147 and 47, 148 of the Act. You know, Lordship, see. Therefore, my lord, in this case, in favor of the revenue, this case, therefore, lordship admit the question of law.
All right, let's hear him now.
Well, let's admit. I am not. He has not admitted. No notice has been issued.
I have.
No, but he's there. He's present here. He
You
can
have no
definitely
case.
oppose the framing of
Yes, I
question.
have case. I have to satisfy. I have to
Yes,
say that I
yes.
have no case.
I am, my lords may kindly see 143.2. 143.2. The Supreme Court time and again has said it is when the assessing officer tinkers with the return. It's a part of the rules of natural justice that I don't believe your return. So adduce evidence in support of the return. That is the purport of section 143.2. And I am giving a list of and two other judgments by my lord in Delhi High Courts. My lord sitting with Justice Iranian. That Lordship may kindly see that the resultant position para 19 is that
No,
as
of which judgment? Which judgment are you reading?
my lords, the judgment just now I have handed over.
Oh, this one.
There are two judgments of my lord.
All right.
My lord's first judgment that Principal Commissioner of Income Tax versus Jai Shivshankar Traders Private Limited. Lordship may kindly see para 19, last paragraph. The resultant position is that as far as the present case is concerned, the failure of the AO by the AO to issue a notice to the assessee under section 143 bracketed 2 of the Act subsequent to so and so 16 December 2010, when the assessee made a statement before the AO to the effect that the original return filed should be treated as a return pursuant to a notice under section 148 of the Act, is fatal to the reassessment. And the second also of your lordship, that is Principal Commissioner of Income Tax versus Silver Line. That also the tribunal.
So para 9 of this judgment, have you seen the para 9 of the judgment is handed over?
Yes,
You've not given him a copy.
Yes, I have given.
The lordship, I am relying on the Supreme Court judgment. Jaiprakash C, the lordship C.
So if you don't read what is being handed over, you go on handing over without reading this, that's a problem, sir.
Yes, Lord, he has not given just now. He has given.
Just read para 9.
Against this order, said order of CIT appeal, the revenue filed the appeal before the IKT.
No, I'm sorry. Para 9. Para 9 of this Principal Commissioner of Income Tax, this is Jai Shivshankar Traders.
Jai Shivshankar Traders.
You have this Jai Shivshankar Traders?
Yes, Lord.
Just see para 9.
Yes. And Dr. Rakesh Gupta, Learned Counsel appearing for the assessee, at the outset draw the attention of this court to an order passed by this court on 7th August 2011 in review petition number so-and-so, ITA number so-and-so, whereby the court reviewed its main judgment in the matter rendered and dated so-and-so on the ground that the said appeal had not been admitted and the question concerning the mandatory compliance with the requirement of issuance of the notice under section 143(2) of the Act. In its review order, the court noted that at the time of admission of the appeal on 17 February 2011, after noticing that in the said case that no notice under 143(2) had ever been issued, this court held that no question of arose on that aspect. The offset of the above discussion is that the decision of the court in CIT was a Madhya Bharat Energy Corporation Shupra is not any assistance to revenue as per the issue in the present case is concerned.
Next para is what you're now relying on this vision incorporation, right?
Yes.
So read that. It will be an answer to your.
Mr. Agarwal nevertheless.
Miss Agarwal.
Miss Agarwal nevertheless argued that notwithstanding the above position, the decision of this court in ITA versus Vision and so and so, the said judgment held that since on the fact that the assessee had been properly served with the notice under Section 142 of the Act within the statute time limit prescribed under the proviso thereto, the ITA should not have set aside the reassessment in toto. Ms. Agarwal placed the reliance of Section 292BB of the Act and argued that the assessee, having not raised any objection about non-issuance notice under Section 143 of the Act, either at the time before the AO or prior to or during the reassessment proceeding, the assessee was precluded from the raising such objection in subsequent stage.
Anyway, that's not even the point here.
No, here also that point was raised.
All right, that's also dealt with. But all right, that's also dealt with.
Yes, Lord, I am relying on Supreme Court judgment. Commissioner in charge was Judge Singh. It's not exactly 148, but the Honorable Supreme Court says the question was framed. I am placing the question, then I come to the final.
So this is a very old judgment. Blue Moon is much later, sir.
Yes.
How can you rely on an earlier judgment when Blue Moon fully applies?
Page 367 of Blue Moon.
Yes.
But the only question that arises for our consideration in this batch of appeal is whether service of notice on the assessee under Section 143 bracketed 2 within the prescribed period of time is a prerequisite for framing the block assessment under Chapter so and so of the Income Tax Act. Then, my lord, Section 158B, that the scheme of the block assessment, the last paragraph, and thereafter the Honorable Supreme Court said, the next page your lordship will kindly see, it is 6, 7, 8. Omission in the middle one, page 8 of my compilation, page 8, in the middle one, my lord got
this Jai Singh is not for reassessment.
No, it is not reassessment.
Reassessment is an entirely different ballgame, sir.
Here the finding says the issuance of notice.
No. And this is on reassessment. We are talking of reassessment.
Yes. Then
when the assessee tells you the return already filed by me should be treated as a return, and you are not believing him, at that stage you have to issue a 143.
Yes, but here fact remain, Lord, he has not filed any further, and he is requested that my return may be accepted and participate in the process.
Correct. No, but that's the whole point in this Jai Shiv Shankar. Same thing was argued.
Yes, everything else.
You see, the question of law, this is an appeal by the revenue against an order dated 21st April 2017, passed by the ITAT and ITA number 372/CTK/2015 for assessment year 2008-09. The question of law sought to be urged by the revenue is whether the ITAT was correct in quashing the reassessment order dated 30th January 2015 of the assessing officer, bracket AO, on the ground that it was completed without issuing notice to the assessee under section 143, bracket 2 of the Income Tax Act 1961, bracket IT Act, paragraph. Mr. T.K. Satpathy, learned counsel to the department, placed reliance on the judgment of the Delhi High Court in CIT versus Madhya Bharat Energy Corporation Limited, 2011 337 ITR 389 bracket DEL bracket, which purportedly supported the revenue's point of view. Full stop. In response, Mr. S. Rai, learned counsel for the SSC, drew the attention of this court to the subsequent judgment in Principal Commissioner of Income Tax versus Sri Jai Shiv Shankar Traders Private Limited, 2016 383 ITR 448 bracket DEL, where in para 9, it has been noted as under A to A. Consequently, the judgment in Madhya Bharat Energy Limited is of no assistance to the revenue paragraph. Mr. Satpathy next relied on the decision of the Supreme Court in CIT Shillong versus Jai Prakash Singh, 1996, 3 SEC 525. The court notes that in this, the said case arose out of a challenge to an assessment order and not to a reassessment order, and examined the effect of non-service of notice under section 143(2) of the Act in that context. However, in the specific context of reopening of assessments as a result of block assessment proceedings, the Supreme Court of India in Assistant Commissioner of Income Tax versus Hotel Blue Moon, 2010, 321 ITR 362(SC), has held that the completion of an assessment pursuant to block assessment without notice under section 143(2) of the Act and within the time prescribed therein would be fatal to such assessment. It is this and other judgments of the Supreme Court that have been relied upon in the judgment of the Delhi High Court in Principal Commissioner of Income Tax, Sri Jai Shankar Traders Private Limited, Supra, which answers the very question raised by the revenue in the present appeal against the revenue in favor of the SSC. Consequently, this court is not inclined to entertain the present appeal by framing the question urged. The appeal is accordingly dismissed.
One point I have to here, my lord, in fact, the notice has not been issued, but he has issued a letter. And you will still know that 143, there is no specific format or rules for notice. 143. Here, my lord, these assessing officer issued note later, not in conformity to 143(2), but he has issued a letter.
All right.
That
Mr. Satpathy then mentioned that just before you end, that although the AO did not issue a notice under section 143(2) of the Act, he issued a letter beyond the time within which such notice should have been issued. This the court is not able to accept as compliance with the mandatory requirement under section 143(2) of the Act. What about the other two appeals?
Same.
All right.
Only
In view of the
different-
order
different
passed today in ITA
different-
20 of 2017, these appeals are dismissed.
Obliged.
All right.
Orders item number 1.
1 and 2 on behalf of Mr. Mahapatra, Your Lordship, he is ill. I am praying for an adjournment.
All right. Counsel for the petitioner is stated to be unwell. List on 22nd April.
Item number 3.
May I please, Your Lordship, I may be permitted to submit on behalf of Mr. Prashanta Sahu, my lord. Here is a petitioner is accused for possessing ganja of the 50 kg, 250 grams, my lord. Of the case is like that, the police has gotten information that in a auto bearing number OD 10J4704 was coming from the side of Saga to the Lamput area.
where the contraband article were being transported. On the midway, they have stopped the auto. They found the five persons were in the auto, and they have found the 50 kilo of ganja from the auto. But nowhere in the affair it has been stated that from which position and from where it is found. They simply wrote that it is found from the auto.
Who are you?
I'm one of the
Passengers.
Passenger, my lord. It is a auto, commercial auto, my lord.
All right. Do you have any criminal antecedents?
No criminal antecedent, my lord.
No. But my humble submission is, my lord, that this petitioner.
Is this commercial quantity?
Yes, my lord.
Yes, my lord. It is commercial quantity, my lord.
Commercial quantity, my lord. And
what's the stage? Charge sheet has been filed.
Yes, charge sheet has been filed.
Charges have not been framed.
No, my lord. And for last 2 years, he is behind the bar. He
No,
was arrested.
Charges are not framed.
Charge has not been framed, my lord.
Why?
Because of this pandemic, my lord.
What has pandemic to do with that, sir?
1/12/2019, he is in custody, my lord.
No. The pandemic and all is gone now. Where is the
now
pandemic?
gone, my lord. Now gone.
Charge sheet was filed on 1/12/2019. So
what about
No. He is in
all other
custody.
accused have been granted bail?
My lord.
What about the other accused? Are they on bail?
That instruction.
No, my lord, no. None of the.
So the exact role will be known when the charge is framed, sir. All right. You
Yes,
renew
sir.
your prayer then. The prayer for bail is permitted to be renewed before the trial court at the stage of charge. The petitioner's application is accordingly disposed of.
Item number 4.
May I please, your lordship? Lord, the petitioner was before your lordship earlier in BLFL number 101 of 2021.
What's the offense, sir?
My lord, 376 read with section 4 of POCSO Act, my lord.
All right. What is the stage, sir?
My lord,
Has the victim been examined?
Yes. Victim and his father, mother, and other 13 witnesses has already been examined.
What does the victim say?
My lord, page 22. It is an.
I have filed, my lord.
An Excel code. The accused. My lord, I'm just reading the relevant portion. When I went near his bathroom, he called me. My lord, the informant of this case, my father. I know the accused of this case, who is our neighbor. On 21/9/2020 at about 9 a.m., the present occurrence took place in the latrine of the accused. On the relevant day and at time, I was going to our bathroom to take bath, and at that time, the accused, while inside his latrine, told me to give him a bucket of water. When I went near his bathroom, he called me inside, to which I refused. The accused, however, forcibly dragged me inside the latrine.
Your Lordship, Your Lordship, page 16, clause 41 is the arbitration clause, my lords.
All right. We say notice returnable 8th April. All right.
Item number 6.
My lord, there is a talk of between the parties. It may be settled, Your Lordship, out of court.
Which one, sir?
6, Your Lordship.
6. I see. Mr. Saragi states that there is a possibility of settlement. List on 22nd April.
Item number 7.
Item number 7, my lords. I'm appearing for the petitioners, my lords. Notice was issued on 21st of January 2021, my lords.
Who's appearing for
Yes,
the?
I'm appearing, my lord. My lord, may grant me last chance for 1 week time to file a reply.
But I would object to this request, my lords. My lords, there is a problem, my lords. The entire case, my lords, has become a cat and mouse run, my lords. My lords, the appointment of the arbitrator, they have been delaying since I have sent them a legal notice, my lords, invoking arbitration.
We'll give a final chance, sir. You say at the request of Learned Counsel for the opposite party, a final opportunity is granted to file reply within by 11th March.
Yes.
2022. List on 25th March. All right.
Item number 8.
8 and 9, my lord, parties are same 2 agreements. Your lordship had issued notice twice. Notice is sufficient. Your lordship may kindly see the item number 9.
Correct. Nobody is appearing.
Nobody is appearing. Nobody has put an appearance. And by taking advantage of this notice, they have even stopped payment of the current rent.
I see. Despite service, none appears for the opposite party in both these petitions. What's the claim, sir?
My lord, it's a house rent agreement. Monetary claim may be less. Any lawyer or any retired district judge can be appointed. It will be, my lord, security money is 90,000 and the rent, it will come around 4 to 5 lakhs. So around 10 to 15 lakhs in total in 2 cases.
Retired district judge or
My
lawyer?
lord, may I pray one thing, my lord? Can
Yes.
senior counsel Mr. DP Dhal be appointed
All
as
right. Mr.
arbitrator?
DP Dal is appointed. Senior counsel is appointed as sole arbitrator to adjudicate the dispute between the parties. The arbitration will take place under the aegis of the High Court Arbitration Center.
Mobilized.
All right.
Item 8 and 9 same. my lord.
Same, correct.
Parties are same.
Two separate orders.
Obliged, your lord.
Item number 10.
Item 10, I have entered appearance on 11th of February, my lord.
All
I'll
right.
be filing a reply to this. Lordship may give me 6 weeks time for this.
All right. Mr. P.K. Ratha states that he's entered appearance on behalf of opposite parties.
Opposite party, no.
One. And will be filing his reply.
My lord, in the last occasion, 4 weeks time has been given for the reply. So 6
No,
weeks
no.
time will be too much
No,
for
no,
this.
On my lord, on last occasion, because there are state also opposite party 2 to 4. Not on my prayer. It's my first appearance.
All right. Replies be filed within 4 weeks, rejoinder for the next day. 29th April, sir.
Yes, sir.
Obliged.
All right.